This is English shorthand dictation number 310 and the dictation speed is 100 words per minute. Ready? Start. Section 138 of the Act makes a civil transaction to be an offense by fiction of law where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person is returned by the bank unpaid either because of the amount or money standing to the credit of that person being insufficient to honor the check or that it exceeds the amount arranged to be paid from that account, such person, subject to the other conditions, shall be deemed to have committed an offense under the said section and be punished for a term which may extend to 1 year or with fine which may extend to twice the amount of check or with both. To make the dishonor of the check as an offense, the aggrieved party is required to present the check to the bank within a period of 6 months from the date on which it is drawn or within the period of its validity, whichever is earlier, and the payee or the holder in due course of the check makes a demand for payment of the check amount by giving a notice in writing to the drawer of the check within 15 days of the receipt of information by him from the bank regarding the return of the check as unpaid and drawer of the such check fails to make the payment of the amount within 15 days of the receipt of the said notice. Section 139 refers to presumption that unless the contrary is proved, the holder received the check of the nature referred to under Section 138 for the discharge in whole or in part or of any debt or other liability. Section 140 restricts the defense in any prosecution under Section 138 of the Act, and Section 141 refers to such offense committed by the companies. Section 142 provides that notwithstanding anything contained in the Code of Criminal Procedure, no court shall take cognizance of an offense under the section except upon a complaint in writing made by the payee or, as the case may be, the holder of the check, and that such complaint is made within 1 month of the date on which the cause of action arose under clause C of proviso to section 138 of the Act. Supporting the judgment of the High Court, the learned counsel appearing for the respondents has submitted that as upon presentation and dishonor of the check by the bank on 28th May 1998, which was intimated to the complainant, a cause of action had accrued. The complainant could be filed the complaint could be filed only within 30 days from the date of the alleged receipt of the first notice by the accused. He contends that as according to the complainant, the postal acknowledgement receipt of the notice was received by the complainant on 15th June 1998. The complaint filed by it after 15th July 1998 was barred by time. During the investigation of a crime, the police agency is required to hold identification parade for the purposes of enabling the witness to identify the person alleged to have committed the offense, particularly when such person was not previously known to the witness or the informant. The absence of test identification may not be fatal if the accused is known or sufficiently described in the complaint, leaving no doubt in the mind of the court regarding his involvement. Identification parade may also not be necessary in a case where the accused persons are arrested at the spot. The Honorable Supreme Court held that the evidence, in order to carry conviction, should ordinarily clarify as to how and under what circumstances the complainant or the witness came to pick out the particular accused person and the details of the part which he allegedly played in the crime in question. In such cases, test identification is considered a safe rule of prudence to generally look for corroboration of the sworn testimony of witnesses in court as to the identity of the accused who are strangers to them. There may, however, be exceptions to this general rule when the court is impressed by a particular witness on whose testimony it can safely rely without such or other corroboration. Though the holding of identification proceedings is not substantive evidence, yet they are used for corroboration purposes for believing that the person brought before the court was the real person involved in the commission of the crime. The identification parade, even if held, cannot in all cases be considered as safe, sole, and trustworthy evidence on which the conviction of the accused could be sustained. It is a rule of prudence which is required to be followed in cases where the accused is not known to the witness or the complainant. It is well settled that the substantive evidence is the evidence of identification in court, and the test identification parade provides corroboration to the identification of the witness in court if required. However, what weight must be attached to the evidence of identification in court which is not preceded by a test identification parade is a matter for the courts of fact to examine. In the instant case, the courts below have concurrently the evidence of the prosecutrix to be reliable, and therefore there was no need for the corroboration of her evidence in court as she was found to be implicitly reliable. We find no error in the reasoning of the courts below. From the facts of the case, it is quite apparent that the prosecutrix did not even know the appellants and did not make any effort to falsely implicate them by naming them at any stage. The crime was perpetrated in broad daylight, and the prosecutrix had sufficient opportunity to observe the features of the appellants. She had also a reason to remember their faces, as they had committed a heinous offense and put her to shame. She had therefore abundant opportunity to notice their features.